All right, so we're back. We're back to Rule 613, prior statements of witnesses. At the outset, you don't need to know about it right now. Just know that just like 404 refers you to the 600 rules, 801 subsection. I'm sorry, 802 subsection D. I think there's a series of things that are defined as not hearsay. One of them is I think one of them is prior consistent statements. Really, that's irrelevant because what I'm really talking about is 803. 803 talks about declarant unavailable, hearsay statements that come in when the person isn't actually here to testify to the hearsay statements. The point is that one of the exceptions for that is prior consistent statements. So remember that there's a corollary between 613 and 804.2c-ish, somewhere around that site. It's going to be 804 subsection 2, maybe subsection C. There's a corollary between the rules. When you understand those rules and how they connect with one another, you'll be able to make more articulate objections because you understand that the rules intersect. We're going to punt on that issue for now. But prior statements of witnesses. 613 subsection A, examining witnesses concerning a prior statement. What does this mean?
I mean, if you ask them about anything in their affidavit or anything, right?
Right.
Just question
You're examining a witness about a prior statement that they made. Not necessarily, I don't think it necessarily means under oath. Yeah, it doesn't mean necessarily under oath. So it could have been a hearsay statement that they said. This is where it would intersect with the 804 rule. So the rule says, in examining a witness concerning a prior statement made by the witness, not someone else's prior statement. So you're talking about something that this person on the stand once said, written or not. Means it could be in a letter form, could be in a sworn statement, could have been just spoken, never reduced to writing. The statement need not be shown, nor its contents disclosed to the witness at the time. But on request, the same shall be shown or disclosed to opposing counsel. It's a retarded rule. Because all this rule really means is it gives you the right, Your Honor, can I see the document before Mr. So-and-so approaches the witness with it? That's all it does. That's all it does. But it also says that you can impeach them off the top of your head if you know the affidavit that well. You don't need to approach them, necessarily to approach them with the statement unless opposing counsel asks for it. Rule of thumb, whenever stuff starts going the wrong way, and you see that your witness is about to get impeached, always interrupt the impeachment in the middle. Your Honor, I just asked to see the document that opposing counsel is referring to. 613 subsection B, extrinsic evidence of prior inconsistent statement of a witness. The difference between 613B and 613A is that 613A is talking about generally prior statements by the witness. Consistent, inconsistent, written, verbal, anything. It's a general rule. That means the general rule is that you need not necessarily approach them with it, but it needs to be shown on request. 613B specifically talks about extrinsic evidence in the context of prior inconsistent statements. Extrinsic evidence of a prior inconsistent statement by a witness, so an impeachment by someone's affidavit, is not admissible unless the witness is afforded an opportunity to explain or deny the same, and opposite party is afforded an opportunity to interrogate the witness thereon, or if the interests of justice otherwise require. Think back to the 5 or 6 questions that I told you guys a little bit ago that you have to ask when impeaching the witness. The reason why you have to ask those questions is because of this rule. This rule requires that you give that witness an opportunity to explain, deny, admit, or reject your characterization of their statement. If we didn't have this rule, you'd have a circus up there. Because you could just get up there and say, well, on such and such date you said this, isn't that correct? No, it is. You did say this. And the whole point is that you're grounded. The impeachment is grounded in Rule 613, subsection B. You have to lock them into that answer. It was on, today you testified to this, you recall giving sworn statement, that statement was under oath, you testified in that, you testified to the opposite in that, isn't that correct? That's the opportunity that you're giving them to admit, deny, reject, or accept your characterization of their statement.
So essentially, if you don't follow that procedure, then they could use that objection.
If you don't follow that procedure, then your quasi-impeachment, I call it a quasi-impeachment because it's really not a correct impeachment, then your impeachment is subject to two objections, two appropriate objections. Anyone know what they are?
Improper impeachment.
Right, and what's the other one? Lack of foundation.
Now, at the end of your impeachment, when you ask somebody, now that I read that correctly, is that their chance to explain?
I would never do that. I would never do that. I've seen many attorneys do that. I've seen many advocates do that, both in law school and in undergrad. I don't like it. Because if I were that witness, my response would be, I didn't say it like that. Where do you go from that? You either move on, and that means the witness got the last word in on you, on your impeachment. Or, I mean, if you have a really wily witness, I mean, like, I've done something like that, well, you know, you have to read it with the proper intonation. I'm sorry, sir? Well, what I meant was that the ball is blue, not the ball is blue. I was excited when I said it. Lays the foundation for an excited utterance. And, like, I mean, you open up a door, you open up a can of worms that you don't want to deal with. I would, and not to mention that it's an open-ended question on cross-examination. So there's 3 reasons why you should never ask that question at the end. The way that you do end it is it still your testimony today? Lock them into what you want them to say. Because then you force them to change their answer. Or look stupid by agreeing to it. Okay, the last sentence of this rule says that this provision being prior inconsistent statements using extrinsic evidence, does not apply to admissions of a party opponent as defined in Rule 801(d)(2). We're not going to go into that in detail right now, but that means that this ban, this limitation is inapplicable to statements made by the person sitting on the other side of the courtroom. So we'll leave that issue for now, and we'll revisit it on a later date. But 614 is simple. Calling and/or interrogation of witnesses by court is not allowed. The reason why this rule exists in your mock trial universe is because that way judges don't start injecting themselves into the case and asking the questions that they want you to ask, but you haven't been asking correctly because you haven't been trained well.
Is there a nice way to say that rule? 'Cause
Yes.
It's happened to us, but we didn't want to sound like
Like a
Your Honor,
jerk.
you can't do that. You know?
Yeah.
Well, like when
And
when
the
opposing
oppo-
counsel makes an objection and the judge leads him to that.
Well,
or
no,
leads
what-
him to a new one.
Like, yeah, I mean, this judge literally, like, was
Ask-
interjecting
They were like,
and
okay, now
asking
you're done
witnesses
asking questions. I'm gonna ask questions. Like,
Okay. There are 2 issues with that. The first issue is that in order to really claim any sort of remedy, there has to be not a violation of the Midlands Rules of Evidence, but a violation of the AMTA rules. And I don't know off the top of my head that the AMTA rules would consider, I don't know that AMTA would consider the rules of the procedure violated by if a judge interjects him or herself into the interrogation of a witness. That's your first issue. The way that I would deal with it is not in what you say, but in how you say it. So, if someone's on the stand and I'm the crossing attorney, and this witness is giving me a hard time, and the judge interjects him or herself into it and starts asking questions, I would wait until my first opportunity to interject, which is at the first pregnant pause. No Casey Anthony pun intended. And I would say, Your Honor, with all due respect, the Midlands Rules of Evidence do require, pursuant to Midlands Rule of Evidence 614, that the judge cannot call or interrogate any witnesses. And with all due discretion to the court, that is improper under these rules. And if your interrogation is complete, may I continue? That's the nicest way that you can deal with it. It's touchy. I don't necessarily recommend it. you may get more points from the scoring judges, because I mean, it takes a rare judge to to sit there in a mock trial undergrad proceeding and be so invested in it that they feel like they have to ask the witness questions, because there's a dilemma in their head that they just can't get straight. Most of them don't care. But if you do happen to encounter one of those judges, normally they're going to be ages 72 to 75. They're practicing law for 25 years and probably grew up in the rural South. If you do encounter one of those judges, then you my advice to you would probably be to just deal with it. Because chances are the other two judges are going to be like, all right, when they're scoring, you're going to be like, all right, that was really unnecessarily difficult. And I know, because I was listening in the judges' meeting, that he shouldn't have done that. So kudos to you for just shutting up and letting him run his mouth and continuing on where you left off. The way that you would be sure that the judges saw that you weren't thrown off by it is you would say, when it came back to you, now, we were, a few moments ago, we were talking about whatever it is that you were talking about. Don't say before the interruption. Or don't even say before the recess or anything. Just say, a few moments ago, we were talking about X. Now, my next question to you about that is whatever. And then you cue to that judge that he probably was interrupting you. You cue to the scoring judges that, look, you got to shut your mouth. And that's it. I mean, also keep in mind that 611, if it existed in your rules, would work against you in this scenario. Because 611A would allow the judge to control the means and mode of interrogation of witnesses, which means I can interrogate witnesses. So that's why that rule was omitted, because then you'd have a conflict in the rules. 615 does not apply to you guys because that constitutes an exclusion of witnesses, and you can never exclude any witnesses.
Well, we were permitted in last year's case to sequester.
Yeah, we can make the motion.
Okay, I'm sorry. I read this to be the exclusion, not the sequestration. Alright, so this is an important rule, so let's go through it. At the request, 615, exclusion of witnesses. At the request of a party, stop there. You have to ask for it. It's not automatic. The court shall. Stop there. If you ask for it, you get it. No discretion, no questions, no argument. If you ask for it, the court has to do it. Shall order witnesses constructively excluded so that they cannot hear the testimony of other witnesses. I don't really understand the logic behind this rule in your context, because if you're going to constructively exclude witnesses, all that means is that you can't ask that witness about what someone else said. It doesn't mean that they can't incorporate what someone else said into their testimony. I mean, a really quick, well-trained witness is going to be able to hear a distinction that came up earlier in the trial and avoid that, or compensate for it. Slip it in, be like, oh yeah, if Harley Kim testified, if presuming that this guy named Harley Kim testified and said that this other guy was drunk, this witness who was constructively excluded heard him say that, he wouldn't say, well, Harley Kim was wrong when he testified. He would instead slip it in and be like, yeah, by the way, this guy that Harley Kim said was drunk, this guy's been sober, straight edge as long as I've known him. You can incorporate that because you heard it. 615 basically has no effect. But the rule goes on to say that it does not authorize the constructive exclusion of a party who's a natural person, an officer. Basically, it gives you the three kinds of people that cannot be constructively sequestered. Vis-a-vis, those are the three kinds of people that you can ask questions about what other witnesses testified to. In other words, since 615 says that a party representative cannot be excluded, you can put the CEO on the stand who has conceivably been sitting through the entire trial, and you can ask him what the scummy reporter that was working for him said when he was on the stand, because this guy was here listening to the scummy reporter testify. And that's what 615